Good morning, Judge. Ladies and gentlemen, I am pleased to open the hearing in PCA case number 2015-28, the case concerning the Enrica Lexie incident instituted by the Italian Republic against the Republic of India under Annex 7 to the 1982 United Nations Convention on the Law of the Sea, to which I will refer in the following as the Convention or ITLAS, or UNCLOS, sorry. I'm joined today by my colleagues and fellow members of the Arbitral Tribunal in these proceedings, Judge Jean Paik, Judge Patrick Robinson, Professor Francesco Francioni, and Dr. Pemmaraju Sreenivasa Rao. I would like to apologize for mispronouncing, if anything. The tribunal was assisted by the registrar and his colleagues at the International Bureau of the Permanent Court of Arbitration. Pursuant to Article 13 of the Rules of Procedure of this arbitration and the procedural order number 8, the Arbitral Tribunal shall meet from today, the 8th of July, 2019, to the following Saturday, the 20th July, 2019, to hear the parties' arguments regarding the jurisdiction of the Arbitral Tribunal as well as the merits of Italy's claim and India's counterclaim. On behalf of the Arbitral Tribunal, I welcome the agents, co-agents, counsel, and advocates of Italy and India to this hearing. Pursuant to Article 23, Paragraph 3 of the Rules of Procedure, as amended by Arbitral Tribunal after consultations with the parties by Procedural Order number 7, the hearing shall in principle be confidential. I note, however, that at the beginning of the proceedings today, the agent of Italy and the agent of India will each make a brief opening statement, which will be webcast live on the internet. No other parts of the hearing will be broadcast. Before turning it over to the parties, I would like to ask the registrar briefly to summarize the procedure and to read out the submissions of the parties in respect of jurisdiction of the Arbitral Tribunal, as well as merits of Italy's claims and India's counterclaims as formulated in their written pleadings. The registrar.
Thank you, Mr. President. On 26 June 2015, Italy instituted arbitral proceedings against India by serving on India a notification under Article 287 and Annex A7, Article 1 of UNCLOS, and statement of claim and grounds on which it is based. On 11 December 2015, Italy filed a request for the prescription of provisional measures under Article 290, Paragraph 1 of UNCLOS. On 18 January 2016, the Arbitral Tribunal held a first procedural meeting with the parties at the Peace Palace in The Hague. On 19 January 2016, having regard to the consultations with the parties at the first procedural meeting, the Arbitral Tribunal adopted its rules of procedure, fixing time limits for the parties' written pleadings on jurisdiction and merits. On the same date, the Arbitral Tribunal adopted Procedural Order number 1 concerning the procedural timetable for the consideration of Italy's request for the indication of provisional measures. Pursuant to Procedural Order number 1, India submitted on 26 February 2016 the written observations of the Republic of India on the request of the Italian Republic for the prescription of provisional measures under Article 290, Paragraph 1 of UNCLOS. And following a public hearing held at the Peace Palace on 29 April 2016, the Tribunal adopted an order in respect of Italy's request, unanimously prescribing provisional measures listed in paragraph 132 of that order. In Procedure Orders number 2, 3, and 4, dated 9 September 2016, 1 June 2017, and 12 February 2018, respectively, the Tribunal, after consultations with the parties, made certain modifications to the procedural calendar for the submission of written pleadings set out in Article 9 of the Rules of Procedure. On 30 September 2016, Italy submitted its memorial, dated 30 September 2016. On 14 April 2017, India submitted its counter-memorial. In its counter-memorial, in addition to responding to Italy's memorial, India also presented counter-claims. On 11 August 2017, Italy submitted its reply on the merits, counter-memorial on jurisdiction, counter-memorial on India's counter-claims. On 15 December 2017, India submitted its rejoinder on the merits, reply on jurisdiction, reply to Italy's counter on India's counterclaims. On 30 July 2018, the Arbitral Tribunal issued Procedure Order number 5, in which it determined that the hearing in the present arbitration would be held from 22 October to 3 November 2018 and fixed the schedule for that hearing. On 27 September 2018, the Arbitral Tribunal informed the parties that the hearing had been postponed, and on 26 October 2018, the Arbitral Tribunal requested the parties to keep in reserve the period from 8 July to 20 July 2019 as tentative dates for the hearing. On 16 May 2019, the Arbitral Tribunal issued Procedure Order number 8, in which it confirmed that the hearing in the present arbitration would be held from 8 July 2019 to 20 July 2019. In its memorial, Italy requests the Arbitral Tribunal to adjudge and declare that, and I quote, A. By the Territorial Waters Continental Shelf, Exclusive Economic Zone, and Other Maritime Zones Act 1976, and Ministry of Home Affairs Notification Number SO 671E, dated 27 August 1981, India has acted and is acting in a manner that is incompatible with UNCLOS with regard to Articles 33.1, 56.1, 56.2, 58.2, 87.1a, and or 89. B. By directing the Enrica Lexie to change course and proceed into India's territorial sea, India violated Italy's freedom of navigation in breach of UNCLOS Article 87.1a. By interdicting the Enrica Lexie and escorting her to Kochi, India violated Italy's exclusive jurisdiction over the Enrica Lexie in breach of UNCLOS Article 92. D. India violated and continues to violate Italy's exclusive right to institute penal and disciplinary proceedings against the Marines in breach of UNCLOS Article 97.1. E. By ordering the detention of the Enrica Lexie between February and May 2012 and investigating those on board, India violated the prohibition contained in UNCLOS Article 97.3. F. The assertion and continued exercise of criminal jurisdiction by India over Chief Master Sergeant Massimiliano Latorre and Sergeant Salvatore Girone is in violation of India's obligation to respect the immunity of the Marines under UNCLOS Articles 2.3, 56.2, 58.2, and 100 as Italian state officials exercising official functions. G. By failing to cooperate in the repression of piracy, India violated UNCLOS Article 100, read with UNCLOS Article 300. H. India's assertion of jurisdiction in the present case was and is contrary to UNCLOS. End of quote. Italy also requests the Arbitral Tribunal to order, in addition or in the alternative, and I quote, A. India must cease all wrongful acts that have caused or continue to cause any of the continuing breaches of UNCLOS in paragraphs 1a, d, f, g, and h above. It shall, in particular, cease to apply the provisions of the 1976 Maritime Zones Act and the 1981 notification insofar as they are incompatible with UNCLOS. It shall also cease to exercise any form of criminal jurisdiction over the Marines, including measures of restraint and legal proceedings in India. B. India must make full reparation for the breaches of UNCLOS set out in paragraphs 1a to h above and re-establish the situation that existed before its wrongful acts. India must in particular terminate all criminal proceedings, including measures of restraint, in respect of Chief Master Sergeant Massimiliano Latorre and Sergeant Salvatore Girone in connection with the Enrica Lexie incident. C. India must pay compensation for the non-material damage suffered by Chief Master Sergeant Massimiliano Latorre and Sergeant Salvatore Girone as a result of India's unlawful exercise of jurisdiction over them, and the material damage suffered in consequence of the detention of the Enrica Lexie. End of quote. In its reply and rejoinder to counterclaim, Italy also requests the arbitral tribunal, and I quote, 1. To dismiss India's objections to the jurisdiction of the tribunal with respect to Italy's claims 1a, 1f, and 1h, and 2. To dismiss India's counterclaims in their entirety and all requests consequential on them. End of quote. In its rejoinder, whose content reflects the submissions set out in its counter-memorial, India requests the arbitral tribunal to, and I quote, 1. Adjudge and declare that it has no jurisdiction with respect to Italy's claims 1a, 1f, and 1h, and to dismiss and reject those claims. And 2. Dismiss and reject all other requests and submissions of Italy. Regarding its counterclaims, India also requests the arbitral tribunal to adjudge and declare that, and I quote, 3. India's counterclaims are admissible, and that by firing at the St. Antony and killing 2 Indian fishermen on board, Italy, 4. Violated India's sovereign rights under Article 56 of UNCLOS, 5. Breached its obligation to have due regard to India's rights in its EEZ under Article 58.3 of UNCLOS. 6. Violated India's freedom and right of navigation under Articles 87 and 90 of UNCLOS. And 7. Infringed India's right to have its EEZ reserved for peaceful purposes under Article 88 of UNCLOS. End of quote. Consequently, India requests the tribunal to order that, I quote, 8. Italy make full reparation for its breaches of Article 56, 58.3, 87, 88, and 90 of UNCLOS. End of quote. Mr. President.
Thank you, Mr. Registrar. I now invite the parties to introduce their delegations. First, let me turn the floor over to the agent of Italy, Mr. Francesco Azzarello, to introduce the delegation of Italy.
Mr. President, members of the Tribunal, agent and members of the delegation of India, Register and of the Permanent Court of Arbitration, it is an honor to represent Italy in these proceedings. Before starting, I would like to pay my own and Italy's respects to Judge Potibanda Chandrasekhara Rao, who sadly passed away last year, and to convey the assurances of our highest consideration to Dr. P.S. Rao. This is how I was set to address you. I have already provided you with a list of all the members in Italy's delegation. The following council will present submissions on behalf of Italy during these 2 weeks of hearing. Sir Daniel Bethlehem, QC, Dr. Paolo Busco, Professor Ida Caracciolo, Dr. Ben Juratovic, QC, Mr. Sudhanshu Swarup, QC, Professor Guglielmo Verdirame, QC, Dr. Philippa Webb, Sir Michael Wood. Mr. President, following the presentation of the Indian delegation by the agent of India, at your invitation, I will return to make an opening statement on behalf of Italy. Thank you.
Thank you, Mr. Azzarello. I turn now to the agent of Italy, Mr. Gadaran Balasubramanian. I would apologize for mispronouncing it. I tried with the help of my colleague, but probably I'm not that talented. To introduce the delegation of India.
Thank you, Mr. President, members of the tribunal, and esteemed colleagues from Italy and India. I, like my co-agent from Italy, I would also like to place on record our sincere condolences for the passing away of Mr. P.C. Rao, and we welcome Mr. P.S. Rao over here. And I would also like to apologize for the wrong or a long and very difficult pronunciation of my name, Mr. President. In short, I would take this opportunity, and thank you for giving us this opportunity to introduce Indian team. I am Balasubramanian, Joint Secretary in Europe West of the Indian Ministry of External Affairs. His Excellency Mr. Venu Rajamani, Ambassador of India to the Republic of Netherlands, is the co-agent. Mrs. Uma Shekhar, Joint Secretary L&T, is another co-agent, and Dr. Luther M. Rangrezi is the deputy agent. The counsel and advocates include Professor Alain Pele, Emeritus Professor, University Paris Nanterre, Mr. Rodman Bundy, member of the New York Bar, Dr. Vishnu Dutt Sharma, Senior Counsel and former Additional Secretary L&T, Mr. Benjamin Sampson, International Law Center of Nanterre, Mr. Alvin Yap, Advocate and Solicitor of the Supreme Court of Singapore, Ms. Joyce Ang, Advocate and Solicitor of Supreme Court of Singapore, Mr. Ludovic Legrand from the Law Center of Nanterre, and Ms. Heloy Bajer Palais, member of the Paris Bar. We also have advisors and members for the team, and they are Mr. Donny Michael, DIG from the Indian Coast Guard, Deputy Inspector General from the Indian Coast Guard, Dr. Sanjay Kumar, Under Secretary from Ministry of External Affairs, Mr. Sendil Kumar, Legal Officer from the Ministry of External Affairs, and Mr. P. Vikraman, Deputy Superintendent of Police from the National Investigation Agency. And thank you for this opportunity. I look forward to coming back to give a presentation of the case subsequently. Thank you.
Thank you, Mr. Balasubramanian. According to the schedule for the hearing, adopted by the tribunal in consultation with the parties, the agent of Italy and the agent of India are each to make a brief opening statement. I give the floor first to the agent of Italy, Mr. Azzarello, to present Italy's opening statement.
Mr. President, members of the tribunal, the dispute between Italy and India that this eminent tribunal is convened to resolve concerns a maritime incident that took place 7.5 years ago in international waters off the Indian coast. The handling of that incident by India and the dispute that followed led to a rupture in relations between the two states, with 2 Italian Marines being detained in India for a number of years without lawful charge, a frustrated investigation by the Rome public prosecutor, and an impasse between the two states over the exercise of rights of jurisdiction, including immunities from jurisdiction in relations to the Italian Marines. The commencement of these proceedings by Italy on 26th of June 2015 was followed by provisional measures ordered first by the International Tribunal for the Law of the Sea, and subsequently by this tribunal, which saw the Marines return to Italy pending the award of the tribunal. With those decisions, and with the calm created by moving the dispute onto the arbitration track, relations between the two states returned to a customary path. The task of the tribunal, guided by and applying the law, will be delicate and important. Let me begin by recalling briefly the factual background to the dispute. On 15th of February 2012, the Enrica Lexie, an oil tanker flying the flag of Italy, was en route from Sri Lanka to Egypt. A vessel protection detachment of EPD, comprising 6 Italian Marines, was stationed on board the ship with an official anti-piracy mandate entrusted to them under Italian law. Chief Master Sergeant Massimiliano Latorre was the head of the Vessel Protection Detachment. Sergeant Salvatore Girone was one of its members. While the Enrica Lexie was navigating about 20.5 nautical miles off the coast of Elapusa, India, a small, unidentified craft was spotted on radar proceeding on a collision course with the tanker. As the boat drew nearer, the Marines on board the Enrica Lexie took a series of visual and auditory measures to urge those on the approaching boat to change its course. It is to be recalled that these events took place in waters in which pirate attacks were known to have occurred, and the common modus operandi for pirate attacks involved the use of small crafts, including fishing vessels. Despite the systematic steps taken to encourage the boat to change its course, it continued undeterred on its collision course with the Enrica Lexie. Faced with this situation and apprehending that this vessel was under pirate attack, that his vessel was under pirate attack, the master of the Enrica Lexie sounded the emergency alarm. He instructed those members of the crew, not indispensable to the safe navigation of the ship, to take refuge in the citadel, secure quarters within the ship. The Enrica Lexie maneuvered to try and avoid the impending collision. Observation through binoculars reinforced the fear that the Enrica Lexie was the target of a piracy attack. The Marines fired 3 volleys of warning shots into the water as the skiff continued to approach. When the skiff finally turned away, it was very close to the tanker, seconds from a collision. The master of the Enrica Lexie and the Marines immediately reported the incident to all concerned authorities, Italian and international. Hours after the incident, when the Enrica Lexie had resumed its navigation and was some 36 nautical miles off the Indian coast, India dispatched armed Coast Guard vessels and aerial units to interdict the Enrica Lexie and escort her to Kochi. On 19th of February 2012, Chief Master Surgeon Latorre and Surgeon Girone were compelled to disembark the vessel by the Kerala police. They were arrested on the spot with an accusation of murder for having allegedly killed 2 Indian fishermen, Agish Pink and Valentine Ayelasten, on board the fishing boat the St. Antony, in the context of the incident that had occurred 4 days before. The Marines' ordeal in India detained and at one point at risk of the death penalty began. At its core, this dispute is about which state, Italy or India, is mandated to exercise jurisdiction over Massimiliano Latorre and Salvatore Girone, members of the Italian armed forces on official duties with regard to what has become known as the Enrica Lexie incident. As members of the Italian armed forces, then as today, the Marines were state officials. They were performing official duties at the time of the incident, exercising official functions under Italian law. They were stationed on an Italian-flagged vessel. The incident occurred in international waters beyond India's territorial sea. As soon as the nature of the incident became known, Italy took immediate steps to investigate the incident. A criminal investigation was opened by the Rome public prosecutor. In parallel, an admiral of the Italian Navy was immediately dispatched to India to inquire into the incident. Both sought the cooperation and assistance of the Indian authorities. No cooperation was forthcoming. Instead, the Indian authorities pressed ahead with their own proceedings. Charges were brought against the Marines before the Kerala courts, later thrown out by the Indian Supreme Court, which went on to invent a novel procedure to try the Marines, although on charges that were never defined. The Indian courts failed to determine the Marines' claim to immunity as required under international law. The prompt assertions by the Marines and Italy that India lacked jurisdiction over the Enrica Lexie and the Marines under the UN Convention on the Law of the Sea were swept aside by reference to India's domestic law, which purported to give the Indian authorities penal jurisdiction beyond its territorial sea. This dispute is rooted in the provisions of UNCLOS. In Articles 87 and 58, which address Italy's freedom of navigation and the rights attendant thereon. In Article 89, which provides that no state may subject any part of the high seas to its sovereignty. In Article 92, which provides that ships on the high seas shall be subject to the exclusive jurisdiction of their flag state. In Article 97, which provides that in the event of an incident of navigation, it is the flag state that has exclusive jurisdiction to investigate the incident. Articles 2.3, 56.2, and 58.2, which require respect for rules of international law and the rights of other states, including concerning the immunity of state officials. Article 100 on the duty to cooperate in the repression of piracy, and Article 300 on the obligation not to abuse rights granted by the Convention. Mr. President, members of the Tribunal, I will leave the development of these and other legal arguments to Italy's Council. In my role as agent of the Italian Republic, I would like to stress 5 important points on this opening submission. First, Italy has from the outset taken every available step to exercise its jurisdiction over the Enrica Lexie and over the Marines. I have addressed this already, and you will hear more about this from Italy's Council during the course of the coming days. For the avoidance of doubt, it is no part of Italy's case that the incident of 15th of February 2012 should not be fully investigated. It should be so investigated, and Italy, from the start, has been committed to doing so. The question in issue in these proceedings is which of Italy and India, or India, can lawfully exercise jurisdiction over the Marines to undertake such an investigation. Second, the prejudice in this case, Mr. President, members of the Tribunal, is the prejudice that India has at every single step caused to Italy and the Marines. The immunity of the Marines was not determined in an expeditious and preliminary manner as required under international law. There have been inexcusable delays of process. Special procedures have been invented in breach of India's own constitution. The conduct of India's investigatory, prosecutorial, and judicial authorities combined to deny to the Marines and to Italy due and proper consideration of law. India's prejudice against the Marines extends to these arbitrational proceedings, in which India, in both its written pleadings and in the earlier oral phases of this case, asserted the guilt of the Marines for the murder of Agish Pink and Valentine Ayelasten. In India's eyes, in its submission, there is no presumption of innocence. The Marines were guilty of murder before charges have even been led. Third, India has suggested over and over again that the natural center of gravity of the Enrica Lexie incident is India, because the incident occurred off the Indian coast and because, as it is alleged, 2 Indian fishermen were killed by the actions of the Marines. The truth, however, is that the law prescribes that the center of gravity of the incident is Italy. The Enrica Lexie was an Italian-flagged vessel. It was in international waters at the time of the incident. The actions of which of the Marines have been accused took place on the Enrica Lexie, even if they are alleged to have had consequences elsewhere. The Marines are Italian state officials and immune before foreign domestic courts. And the territorial link with India, such as it is, was a consequence of the Indian authorities unlawfully interfering with the freedom of navigation of the Enrica Lexie following the incident, and of trickery by the Indian authorities that brought the Enrica Lexie into Indian waters. Fourth, the rights that Italy seeks to vindicate in this arbitration are rights that belong to Italy as a matter of international law. Away from the legal technicalities of this arbitration, however, Italy also wants to stress that those who serve in the armed forces of a country render a noble service to their nation and, in circumstances in which wider objectives are pursued, to the international community as a whole. The immunity of members of the armed forces of a state from foreign criminal jurisdiction is recognized worldwide. India has not hesitated to assert the immunity of its state officials, including members of its armed forces, who are deployed in large numbers around the world as members of international peacekeeping contingents. Italy is confident that India, away from the political spotlight of this case, would be the first to defend the principle that members of its armed forces are immune from the criminal jurisdiction of a foreign state. Finally, Mr. President, members of the Tribunal, while the Marines are now in Italy, their deprivation of liberty continues. Italy was grateful when in 2015 India allowed Chief Master Sergeant Latorre to return to Italy after he suffered a stroke while detained in India. The provisional measures ordered of this tribunal in 2016, in respect of Sergeant Girone, recognized that considerations of humanity apply as part of the law of the sea. Considerations of humanity remain relevant. By the end of this arbitration, Massimiliano Latorre and Salvatore Girone will have been subject to various degrees of deprivation of liberty without any lawful charge for over 8 years. The further investigation that is required in this case and any subsequent procedure should take place in Italy. Let me emphasize that Italy recognizes India's interest in the incident, as well as the high personal interest of the families of Agish Pink and Valentine Ayelasten. Considerations of humanity are relevant here as well, and Italy would, of course, take all appropriate steps to ensure that their interests are addressed and respected in the Italian investigation that will follow a finding in favor of Italy in these proceedings and any proceedings that may follow, including by facilitating their participation and representation in such proceedings. Mr. President, members of the tribunal, in April 2016, this tribunal ordered Italy and India to cooperate to allow the return of Sergeant Girone to Italy under the authority of the Supreme Court of India. The Supreme Court of India has, on the same basis, allowed the extension of Chief Master Sergeant Latorre's stay in Italy for the duration of this arbitration. Those were wise orders that brought Italy and India to the path of normalizing their relations after years of tension caused by this incident. The cooperation that the tribunal has required of Italy and India with respect to Sergeant Girone's return has extended to other areas as well. The proceedings in this arbitration are an example of the positive role that an Annex 7 tribunal can play in bringing accord back to once riven relations between states. Italy is grateful for the new course on which the tribunal has set Italy and India. We trust that India shares Italy's wish that the tribunal delivers an award that fully and finally resolves the dispute between them on the issue of the lawful exercise of jurisdiction over the Marines. Mr. President, members of the tribunal, this concludes my opening statement. Thank you, Mr. President, and members of the tribunal.
Thank you, Mr. Azzarello. I now give the floor to the agent of India, Mr. Balasubramanian, to present India's opening statement.
Mr. President, distinguished members of the tribunal, it is indeed an honor for me to present before you an overview of the facts, circumstances, and the legal position in the present case in my capacity as the agent of the Republic of India. The gist of the subject matter brought by Italy against India essentially concerns the tragic killing of 2 innocent Indian fishermen on board an Indian fishing boat in India's exclusive economic zone. I would like to touch briefly on the facts of this so-called incident. On 15 February 2012, at about 4:30 p.m. Indian Standard Time, the Indian boat named St. Antony, while at a distance of about 20.5 nautical miles from the Indian coast, faced a volley of shots originating from 2 uniformed persons on board an oil tanker, which was a few hundred meters away from the fishing boat. The firing incident killed Mr. Valentine Jelastin and Mr. Ajish Pink on board the fishing boat. It is difficult to believe that these volleys were simply meant as warning shots, as alleged by Italy. They hit 2 crew members, caused damage to the boat, endangering its safe navigation, and also endangering the lives of other 9 crew members on the boat. As a natural consequence, upon receiving the report of the killings, the Indian authorities, as they were supposed to act upon it, started inquiring into the killings in accordance with the applicable law. It was ascertained from the vessel movements in the area that the Enrica Lexie could be a vessel involved in the firing incident. Once that was confirmed by a crew member on the tanker, the vessel was requested to turn back and join the investigation. There was no ruse and no coercion, as alleged by Italy, in persuading the Enrica Lexie to collaborate, only a request that was confirmed in writing. The shipmaster decided to accede to that request and to come to Kochi port. After it was prima facie established that 2 of the 6 Marines on board the Enrica Lexie had fired the shots, killing the 2 innocent fishermen, they were arrested when they were on Indian territory. Legal proceedings were then commenced in the Indian court of Kollam in the state of Kerala. Mr. President, the commencement of an investigation and court proceedings in light of the facts of this case and in circumstances where the alleged accused were available on the territory of the country of the nationality of the deceased victims is, legally speaking, entirely natural. Mr. President, members of the tribunal, it is my firm view that no legal or administrative authority would deny, on both legal and humanitarian grounds, to recognize the immediate requirement for carrying out a prompt inquiry and investigation of the 2 killings. Therefore, without prejudice to the outcome that may result from the judgment of the trial court, the quick action and efforts of the Indian authorities deserve not criticism of the type leveled by Italy, but rather support. Italy's attempt to find fault with the actions taken by the Indian investigation authorities and the courts is not only unjustified, it would have the perverse effect of discouraging law enforcement agencies worldwide. Concerning Italy's often repeated allegations of delay in the Indian court proceedings, Mr. President, the reality of the fact forces me to say that, had Italy cooperated with the prosecution of the killing incident, this case would have been finally concluded long ago. Italy initially joined the proceedings before the Indian courts, but surprisingly in a negative way, hampered them by filing multiple interlocutory applications challenging the actions of the Indian authorities. Mr. President, members of the tribunal, the case proceeded in the Indian courts, first before the Kerala court and then before the Supreme Court, followed by an establishment of a special court for that purpose. Adopting a negative posture, however, Italy chose the course of delaying it further by filing continuous applications, which are nothing but designed to thwart the special court, and then by instituting the present proceedings under Annex 11 of UNCLOS, years after the incident had occurred. At that point in time, Sergeant Latorre was in Italy on leave granted by the Supreme Court of India on health grounds, and Sergeant Girone was on bail in India, allowed to reside at the residence of the Italian ambassador in New Delhi. This clearly articulates how reasonable and cooperative India has been treating the Marines and Italy during the proceedings before the Indian courts. Italy, soon after instituting the arbitration proceedings, as we all know, sought provisional measures from the International Tribunal for the Law of the Sea, ITLAS, in July 2015, pending the constitution of the arbitral tribunal. Italy had requested ITLAS to preclude India from taking or enforcing any judicial or administrative measures against the 2 Marines in connection with the case and from exercising any other form of jurisdiction over the case, and that India shall take all measures necessary to ensure that the restrictions on the liberty, security, and movement of the Marines are lifted to enable Sergeant Girone to travel to and remain in Italy, and Sergeant Latorre to remain in Italy throughout the duration of the proceedings before the Annex 7 tribunal. It is pertinent to mention that ITLAS did not find merit in prescribing the provisional measures as requested. Instead, in its order dated 24th August 2015, with respect to Italy's first measure, ITLAS prescribed a different provisional measure to the effect that both Italy and India shall suspend all court proceedings and refrain from initiating new ones, which might aggravate or extend the dispute submitted to the Annex 7 tribunal, or might jeopardize or prejudice the carrying out of any decision which the arbitral tribunal may render. Accordingly, the parties complied with the provisional measure as prescribed by ITLAS. Concerning Italy's second provisional measure sought from ITLAS, that is, seeking a relaxation of the Marines' bail such that, insofar as relating to Sergeant Girone, he be allowed to travel to and remain in Italy until the end of Annex 7 proceedings, ITLAS did not accept Italy's request. Rather, The tribunal observed that the provisional measures order must protect the rights of both parties and must not prejudice any decision of the arbitral tribunal to be constituted under Annex 7. Mr. President, members of the tribunal, interestingly, Italy did not stop there. On the constitution of your tribunal, Italy once again in December 2015 requested for the additional provisional measures that India shall take such measures as are necessary to relax the bail conditions of Sergeant Girone in order to enable him to return to Italy, under the responsibility of the Italian authorities, pending the final determination of the Annex 7 tribunal. At that time, Italy included no request with respect to Sergeant Latorre. This tribunal, after hearing the parties on 30th and 31st of March 2016, while its order dated 29th April 2016 prescribed provisional measures regarding cooperation between Italy and India for relaxation in the bail conditions of Sergeant Girone on consideration of humanity. That Sergeant Girone, while remaining under the authority of the Supreme Court of India, may return to Italy during the present Annex 7 arbitration as was accepted during the hearings by the then agent of India. Accordingly, the arbitral tribunal confirmed Italy's obligation to return Sergeant Girone to India in case the arbitral tribunal found that India has jurisdiction over him in respect of the Enrica Lexie incident. And the arbitral tribunal asked Italy and India to report on compliance with these provisional measures. Thus, the tribunal, having regard to humanitarian considerations, which has been accepted by India, allowed the temporary transfer of Sergeant Girone to Italy only during arbitration proceedings. Recognizing the legal and judicial requirements, the tribunal also ruled that the accused remain under the authority of the Indian Supreme Court and that both the Marines would be returned back for trial in India in case the tribunal finds that India has jurisdiction. India fully cooperated with Italy in giving effect to the tribunal's order. The ambassador of Italy filed an undertaking on affidavit before the Supreme Court of India that Sergeant Girone shall be returned to India within 1 month of the decision or direction of the arbitral tribunal, requiring him to do so, or as directed by the orders of the Supreme Court. Accordingly, Sergeant Girone left India on 27th May 2016 and reached Italy on 28th May 2016. Mr. President, members of the tribunal, India thus fully complied and is still complying with the provisional measures prescribed by this tribunal in its order of 29th April 2016. Under the current phase of proceedings, this tribunal will hear the parties on the merits of Italy's claims in its notification dated 26 June 2015, as well as India's counterclaims. The principal claim of Italy, as contained in paragraph 33C of the notification, is that Italy has exclusive jurisdiction over the Enrica Lexie and over the Italian Marines in connection with the Enrica Lexie incident in accordance with the provisions of UNCLOS. Mr. President, according to Italy's assertion, India does not have the jurisdiction at all, despite the fact that 2 innocent Indian citizens were killed on an Indian boat and India has apprehended the accused persons when they were in its territory. To determine whether Italy's claim that it has exclusive jurisdiction is valid, the question before the tribunal is entirely legal in nature. The tribunal is essentially to determine whether there is any provision at all in UNCLOS applicable to the incident, and in particular, which support Italy's claims in the facts and circumstances of this very particular killing incident. In other words, is there any provision granting Italy exclusive jurisdiction in circumstances where 2 human beings located on an Indian boat were killed as a result of actions coming from individuals on board a commercial vessel? Mr. President, as we have shown and will continue to do so, Italy's claims that India breached certain specific provisions of UNCLOS do not stand up to legal or factual scrutiny. It is rather India whose legal rights under UNCLOS have been violated by Italy. It has to be kept in mind that India and its fishermen are the true victims in this case. It is for this reason that India had introduced counterclaims, which arise as a result of Italy's breach of India's sovereign and other rights in its exclusive economic zone by its marines firing automatic weapons at an Indian fishing boat, the St. Antony, that was fully entitled to be operating in the area without being harassed, let alone shot at, and having 2 of its crew members killed and the boat damaged, forcing it to return to port. Mr. President, members of the tribunal, you might have seen that Italy, throughout its written pleadings, knowing perhaps that its claim would not withstand legal scrutiny under provisions of UNCLOS before this tribunal, has tried to create a state of confusion by raising issues concerning the investigation, India's domestic legislation, and certain other factual and practical aspects that this tribunal lacks jurisdiction to deal with. Such issues form the subject matter of proceedings before the domestic trial court and not before the arbitral tribunal, whose jurisdiction is limited to matters concerning the interpretation and application of UNCLOS. Italy's attempt to burden the tribunal with such issues is abusive and seeks to have this tribunal equated to that of a municipal court, which, in my view, is unfortunate. It was open to Italy as early as in 2012 to bring its claims before an Annex 7 tribunal under UNCLOS, if Italy were so legally sure about its exclusive jurisdiction in the facts and circumstances of this particular case. Resorting to these proceedings after 3.5 years shows that any delaying tactics lay squarely at Italy's door. Italy has been alleging violation of the rights of the Marines and denial of fair trial, but even a cursory review of the situation of the Marines reveals the opposite story. Despite the severity of the crime that they are charged with, the Marines have been out on bail and, pursuant to provisional measures ordered by this tribunal, are in Italy. Given the status of work of investigating agencies in this process of criminal prosecution, the case has been practically ready for trial for some time. It is Italy which is not allowing the prosecution to progress further. Speaking from the technical legal standpoint, who would know better than this tribunal that Italy has already submitted to the jurisdiction of the Indian courts by using the Indian courts in responding to the issues relating to prosecution and in filing the various petitions for different prosecution purposes. The spirit of justice demands that Italy cease employing such delaying tactics to further impede the trial proceedings, extend its full cooperation with the justice system, and raise any issue, including relating to jurisdiction before the trial court. This behavior of Italy could certainly result in the early conclusion of the proceedings and a decision in the case of the killing of Mr. Ajish Pink and Mr. Valentin Jellastin. Mr. President, I will leave it to the other members of India's legal team to develop the relevant facts and legal principles in more detail. Having given you a flavor of what this case is about and equally what it is not about, I have concluded my opening remarks. Thank you.
Thank you, Mr. Balasubramanian. This concludes the parties' opening statements. The remaining portion of the hearing will be confidential. The live transmission will now conclude.